Welcome to Win with the Law with your host, Gary Newland. In the Win with the Law podcast, your host, Gary Newland, partner at Newland Newland LLP, invites guests who are experts in the personal injury law arena and other areas of law of interest to discuss topics relevant to the general public. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Now here's the host of Win with the Law, Gary Newland.
All right, well, welcome to Win with the Law. Learn how to navigate the legal landscape and end up on top with the help of the legal community's most prominent lawyers. My name is Gary Newland, a trial lawyer with Newland Newland LLP from Arlington Heights, and we have an office in Chicago and Libertyville. And I'm introducing here my partners, Stephen Newland and Jen Carroll. We will be discussing issues and strategies to help you become more successful when it comes to certain legal issues. And what we're specifically going to be discussing today is foreclosure and loan modification. How do you come out on top when the bank is trying to take your house? Well, without further ado, I would like to provide you some background on Steve Newland. He's a senior partner at Newland Newland LLP. And he's broadcasting today from Libertyville. I'm in Arlington Heights, and Jen, are you in Libertyville office?
I'm in Northbrook.
Northbrook, and Jen is a partner at Newland Newland as well. Steve is a senior partner and heads up the real estate and estate planning division, and included in the real estate division is foreclosure and loan modification. And Jen is a very experienced foreclosure loan modification attorney, one of the most experienced in the country. I'd like at this time to let them say a little bit about their background. Steve, if you would begin.
Oh, sure. Well, I've been an attorney now for over 30 years. Been partners with Gary for over 30 years. And while Gary focuses on the injury part of the practice, which he excels at, I focus on the areas that Gary had mentioned previously. I truly love helping people who are in foreclosure, who have issues with their mortgage. They want to save their house. They want to maybe get out of their house without the lender chasing after them, and these are all things that we help people do, and it's very rewarding, and we're very successful in doing it.
Jen, can you tell us a little bit about your background?
Yeah, I've been an attorney for just under 16 years. I've been working for Newland Newland for about 12 of those years. And in those 12 years, my primary focus of my practice has been mortgage foreclosure defense, both residential and commercial. My focus is litigative in nature, and I've been litigating foreclosure defenses for well over a decade. I litigate in Chicago and all of the surrounding collar counties within the Chicagoland area, and it's something I have extensive experience doing.
So, I wanted to ask you two, and either of you can chime in with this. There are different levels of win in foreclosure. It depends on what your client's goals are. Is that correct?
Well, yes, because when people think of winning in a legal context, they typically think of prevailing in the underlying litigation, and that's not typically the goal of our practice area, because at the end of the day, most people who end up in a mortgage foreclosure situation have in fact not been paying their mortgage. And so a lot of what we do is we look for small litigative wins and large litigative wins that put us in a position to have the right kind of um, to be in a good position to negotiate what it is the client ultimately wants. If it's to keep the house, it's to negotiate lower loan payments, to negotiate a reinstatement of the loan via a loan modification, allow them a mechanism to rework the loan so that in a manner that they can then continue to pay and remain in their home and move forward in a productive manner in relation to the continuing relationship between them and the bank. Sometimes it's simply uh, getting them enough time to be able to uh, dignify to transition out of their home in a dignified manner and to give them the ability.
I wanted to ask you a question. So, what I've noticed from when I'm talking to people, one of the biggest issues is, they're trying to do the loan modification on their own. And while they're working on the loan modification, the bank's lawyers take the house from them and they don't even have a chance to get it. Is that common in Illinois, and is it that way in other states? Do you know?
Well, it's common in Illinois, particularly when the programs that are being reviewed are not federally based, because there are certain programs that when they're under review from there are federal regulations that disallow the mortgage company from moving forward with the foreclosure case. But most of those programs have expired. Those were those are the emergency programs that were put into place during the crash after 2008, when the market went to literal crap and everybody was underwater. Interest rates were soaring on those adjustable arms. Property values had plummeted. There was an unprecedented amount of foreclosures, and so the government prepared a bunch of these created a bunch of these programs, it provided huge amounts of funding for these programs, and that funding was available to these banks. I mean, it was part of the large bailout that happened during that time. And because of that, there were all these regulations related to having received that funding. And those regulations included having to offer these programs. And then while those programs were under review, uh, that the bank could not move forward during that review process. The problem is most of those programs, if not all of them, have now expired, but those are the programs people are familiar with. So they have this false sense of security and belief that now if they're working with the bank can't move forward, because for a time that was largely true with the programs that were available. That is no longer the case. There are still some programs, particularly for mortgages that are insured by the federal government in a special manner, such as FHA loans, VA loans. But just because your loan is government backed, which the vast majority of residential mortgages are, they're either backed by Fannie Mae or Freddie Mac. They're no longer required to suspend the foreclosure proceedings when they're doing many of these reviews. So yeah, it's extraordinarily common for them to continue to push forward, and so it's a race. I have a judge in McHenry County who used to give a speech where she would refer to it as two ships racing to the port, and they're both going to continue to move, and it's whoever gets there first, in reference to your loss mitigation efforts in the litigation.
One ship is the loan modification ship, and the other one is the bank's lawyers, right?
Exactly.
Right. And I will say that it's very common. It's very common that we get calls from people who say, I've been working with the lender on a loan modification. They said they'll work with me. I'm sending in my financials and this and that. And I just got a notice that the auction is tomorrow. So they were going through the whole process. The lender was taking the foreclosure judgment, setting it up for auction, and they're just assuming, oh yeah, the bank's gonna work with them, and they get to go through this process, and the lenders get. Well, no, you can't assume that. So it's always advisable to hire an attorney who knows how to basically stop the foreclosure case, use that as leverage and time to get the lender to hopefully work with you. And otherwise, a lot of times they're going to march right through. And then, and so, is it often too late? Sometimes it's too late at that point. Now, yes, we've been able to undo things very late in the case for people, but every case is different. And so we always prefer to get involved early on, but as opposed to, at the very end of the case.
No matter what your situation is, no matter what the fact patterns of your cases, you are always going to be in a significantly better position the earlier you get an attorney.
Are you recommending that they hire an attorney earlier in the process to make sure their rights are protected?
Absolutely, because the foreclosure process is almost unlike other litigation. It is almost a series of mini litigations in many processes where where you have rights that expire at all these various times within the foreclosure litigation. You have your reinstatement right, you have your right to redemption, you have your right to a payoff, and all of these expire at various times in the litigation. And so you're going to be able to preserve the earlier you get a legal representative involved, the better position they're going to be in to preserve as much of your rights and as many of those rights as possible.
Okay, so the earlier on, the more rights can be protected. And bank lawyers, as they proceed with the process, they're taking rights away as the natural process of foreclosing on the property in Illinois. Is that correct?
Yeah, well, it's not even a it's not even a matter of them being taken away. They just kind of naturally expire at certain points in the litigation, and there are things we can do to extend that to to keep it from to delay that process and keep those natural expiration points from occurring as early as they would if you simply allowed the litigation to move forward without any kind of representation.
So I was wondering if you guys could share with us certain successes you had. You hear those stories about how people sometimes get to keep their house and they don't have to pay the bank. Is that something you've ever experienced?
I mean, keeping a house, that's a very keeping a house without having to pay is an extraordinarily unusual measure, but it is something that does happen. It is usually due to a procedural misstep committed by the bank in pursuing the loan and pursuing the litigation against the borrower. It is not uncommon, and it was extremely common in the height of the foreclosure boom for banks to to throw huge amounts of cases at law firms, and then these firms would just do mass filings of these foreclosure cases without having properly reviewed what they had, the documentation, whether or not the pre-foreclosure steps had properly been taken. And so then they get to a point in the litigation where they realize that they're not going to be able to, even on a default, even completely uncontested, they're not going to be able to provide the backing needed to obtain a judgment because they are not going to be able to provide the necessary paperwork showing what they've done. So the banks got in these situations where they'd have to take a voluntary dismissal, which is where they simply just voluntarily closed out the case. And under Illinois law, once you've taken a voluntary dismissal, you're only allowed to refile that case one additional time. It doesn't matter. It doesn't matter whether or not the statute of limitations doesn't expire for another 10 years. None of that matters. You get one extra bite at the apple. And what I've come across in my practice are cases that had been dismissed out 2, 3, up to 4 times for various reasons, and then refiled. There are situations where the voluntary dismissal will not trigger the one refiling rule. So if the voluntary dismissal was based on a settlement, was based on a loan modification, and a new contract was formed, this rule is not going to apply. But in these cases I came across, that wasn't the case. What I highly suspect was the case is that they didn't provide proper pre foreclosure notices, and then they dismissed out, and then failed to provide them again, and then dismissed out again. And so on those cases, we are able to go in, we're able to argue the single refiling rule. And I've had various successes with the single refiling rule, both in foreclosure and in post foreclosure suits on second notes. So when you have a second, like a HELOC or a second loan lien on your house, and that house goes into foreclosure, and the house sells through a judicial sale, and it's not enough to pay off both lenders, that second lender still is owed a debt. So they still have a right to sue on the underlying note, unless they've sued you 3 times and dismissed out those cases. And so I've had success with the double dismissal rule, both in actual foreclosure cases, which does result in the bank not only not getting paid, but not being able to pursue either a suit on the note or a foreclosure action against the defendants. And I've also had success with it on cases where it's just suits on the note, and maybe they had brought a prior foreclosure action, maybe they'd done prior suits on the notes and dismissed out. But at that point, you just don't owe the debt anymore. And
We've been successful in getting cases dismissed with prejudice, meaning the lender can never file another foreclosure case. We've been successful in getting lenders to just dismiss the case and provide a release. Okay. So, but those aren't very common. So we let our clients know that, in most of these types of foreclosure cases, if we can just put up a good enough defense, that will be enough to get what the client wants. Now, the thing is, what's a victory? What does the client really want? In some cases, they want to keep the house. They want the lender to just rework the terms of the loan so they can keep it, make it more affordable. Maybe knock money off of it, whatever their goal is. In some cases, they don't want the house. They know they can't afford the house anymore, but they don't want the lender coming after them for the enormous deficiency. So many times we use a good foreclosure defense to get the lender to say, "Great, yeah, we'll waive everything your client owes us. Just give us back the house." So we work out, often known as a consent foreclosure, where it's like an agreed foreclosure. While we are successful in getting cases dismissed where the lenders can never foreclose, those are rare. We often use it as leverage to get lenders to just rework the terms of the loan. If our client wants to save, what's the client's objective? If their objective is to save the house, then we can use that as leverage to get really good terms on a workout of the loan, a modification. Or it may be they don't want the house. They just don't want the lender to take a money judgment against them for the deficiency, the shortfall, which happens. In Illinois, the lenders have the right to take a money judgment for their losses. And a good foreclosure defense can provide leverage to get the lenders to ultimately drop that.
Well, and to that end, in the vast majority of the cases where we have successfully gotten a foreclosure suit dismissed with prejudice, that has not stopped the banks from refiling the foreclosure, because the law in Illinois is contradictory in our appellate decisions to a point where there are some arguments you can make relating to what's called a continuing default that will allow them to just kind of file into perpetuity. Every time that's happened, I've been able to get the case dismissed again with prejudice, but then they refile it. And so it is kind of just it can end and it can result in this perpetual stream of litigation where, ultimately we prevail, but to what end? And so on most of the foreclosure ones, we do just use it to get extraordinarily good settlements on it. One of them, they didn't want to keep the house, so we were able to not only get them out of any debt, but have them walk away with a large amount of money that the bank paid them to leave. One of them, they just kept defending the foreclosures because they wanted to keep the house, and eventually the bank just stopped filing them. So another one, we were able to get a really, really favorable loan modification that kicked off a bunch of knocked out a bunch of the principal and brought the interest rate and stuff down. Because like I say, even if you get the case dismissed with prejudice, you could be facing appeals. Like the litigations it's kind of never over unless the bank just finally writes it off, and they tend to fight really hard before they'll do that.
With respect to Steve, like approximately how many foreclosure defense cases have you guys handled over the years?
Well, we do a lot of them, and it's so we're very experienced, but it's been in the thousands of cases that we have handled. So we have a very large practice.
And that would be involving what most banks in Northern Illinois. Is that fair?
Well, our cases are in all counties of the Chicago metropolitan area. So all the counties from Lake County, McHenry, to Will, to even Kane and Cook and what's that other one we got right now? Kendall, right?
Oh, maybe not Kendall.
So, Steve, let me ask you another question. How does bankruptcy impact this foreclosure process?
Well, bankruptcy is very interesting. Not all of our clients who come to us who are in foreclosure need to file a bankruptcy. Many times, if it's primarily a house situation, they don't really need a bankruptcy because usually we can get something worked out with the bank by defending the foreclosure case. However, especially if the people have a lot of other debt, bankruptcy can be used to, eliminate that other debt, which then in turn will make it easier for them to be able to make mortgage payments if we work on a modification, so it can help them save the house. In a Chapter 7 bankruptcy. A Chapter 13 bankruptcy is a restructuring of the debt where they get time to get caught up on the house and their other debts. And that can be an option for them as well, especially if the lender is just not willing to work with them on terms that will, that they find favorable. However, though, if you do a Chapter 13 restructuring, your payment is going to be higher because you have to pay the mortgage payment going forward, plus the arrearage gets added to each monthly mortgage payment, and it gets spread out over 5 years. So a lot of our clients, maybe can't afford that additional amount. They really need us to fight the lenders to get as good a modification as possible, so that the payment will be lower and not higher like it would be in a Chapter 13 bankruptcy.
So, Steve, along those lines, Chapter 7 bankruptcy, that's a bankruptcy where you wipe out everything you owe. Is that correct?
Well, not every debt, but like student loans aren't dischargeable. But yeah, many debts just go away. So if you have a house and you have a mortgage on it, and you owe money on it, and you file a Chapter 7 bankruptcy, you do not owe the debt. The lender cannot pursue you for any deficiency, for any of their losses from a foreclosure, if you did a Chapter 7 bankruptcy. But they can still foreclose because the house is the collateral for the loan. So they still have the right to pursue the collateral. So just because you file a Chapter 7 doesn't mean, you get a free house. It just means they can't go after you personally. So you still need to work out a modification with the lender ultimately and defend the foreclosure if you don't want them taking the house so easily, so that you can preserve your rights.
Okay, so essentially, they can foreclose on a loan even if the person who owns the house doesn't owe the money anymore because they filed bankruptcy. Is that correct?
Right, because what they're foreclosing on is the lien, the mortgage lien. And when you buy a house and you sign a note which promises to pay the lender, and you also sign a mortgage which gets recorded against the property to perfect their security interest in the house.
The way I like to explain it to clients is you don't owe the money, but your house does.
Yeah, so you can still lose your house in foreclosure if, in fact, you did a bankruptcy if you're not paying the lender, because the house is the security that you pay it. So, but a bankruptcy can be an important tool in helping you save your house, because there are some people who want to save their house, but they just have so many bills. They're paying more on debts than their mortgages, and there's just, so we have to recommend a bankruptcy because there's just no way they can get out from under that any other way. And
Now,
so,
what about, Steve? Does a bankruptcy prohibit someone from getting a loan modification?
uh, no, no. In fact, we've seen it many times. Lenders may not want to work with the client because they have just too much debt. Okay. And there's a big deficiency. So they're worried about their ability to pay, and they're worried that the lender's going to have just a bigger loss down the road. So they just want to foreclose. So we've seen it where clients have filed a bankruptcy, discharged the debt, and then the lender is even sometimes more willing to work with them on a modification, because now they see, hey, they they have the ability to pay on this. And also the lender knows that since they did the bankruptcy, they're never going to get anything out of this unless they do work out something with the client. On the other hand, we've had clients come into us who have a lot of debt. They're servicing a lot of monthly debt, uh, but they're behind in their mortgage and they're not paying. And so many times, and maybe our clients can't do a bankruptcy for one reason or another, or they just don't want to. Well, during that period of time they're not paying the mortgage, they use that as a time period to pay off the other debt. And maybe, we defend a case, which stretches out the time period. And maybe the following year, they paid off all their debt because they didn't have to pay the mortgage. And now they're ready to do a loan modification. And we get the loan modification then. So there's things can play out different ways.
Do you find that most people that are raising a foreclosure defense are really doing it because they want to keep their house and they want to work out a loan modification that is something they can afford?
Yeah, most of our clients that come in foreclosure, they do want to save their house. Most of the people, they want the lender to work with them. And many times they've been trying to work with the lender for a long time, but the lender just isn't. And so now they're in foreclosure, and now they get us involved. And generally when there's enough income to make it work, where they can at least pay on this thing, generally we're optimistic we're going to be able to save their house for them. And we're optimistic. We can't guarantee it because some lenders are just, very, very difficult, of course. But
And they have to have an income to support a payment under a loan modification. Is that fair?
yes, you need to show the ability that you can pay on the loan. And we have some clients who don't have any income, and they call us because we want to save our house, but you don't have any income. So what the plan will be, okay, when do you think you will have sufficient income? Well, I'm hoping to get a job, or get a second job or whatever, and it may be, or I'm waiting on disability to kick in. Okay, well, what we'll do is we'll defend the foreclosure. We'll put, to push things well out, and hopefully by then, at some point in the future, you'll have the income, and then we can apply for a modification. Because we have to show you can make the mortgage payments, and even if the lender didn't look at that and they offered you a mod, how are you going to pay it anyways without the income? So there's strategies for that, and those strategies will involve just fighting the lender on the foreclosure to push things out until our client gets on a better footing.
Jen, if I can ask you a question, is it fair to say that generally the foreclosure law firm's job is to take the house from the consumer, from the homeowner, as quickly as they can within the rules?
Oh,
Is that
absolutely.
fair?
Yeah, absolutely. That's what they're hired to do. That's them doing their job, is to get the collateral back to the bank, or as quickly as possible. So from their perspective, so that to limit the damages and to get to preserve the value of the collateral for as long as possible, because the reality is that they know that, even though they're entitled to, and they now almost exclusively always take money judgments where the house is worth less than what is owed on the loan. It's very difficult, and it's expensive and time consuming to collect on a money judgment. So they're going to want to get the house back as quickly as possible, because that's going to maximize the value that house is to them.
Yeah. And the longer, some people will even take out the plumbing and sell the metal and leave the bank a shell of a home. Have you seen that?
You hear those horror stories, and I have absolutely no doubt that it goes on. But I can say, as far as our clients go and stuff like that, we don't that it doesn't happen. It certainly doesn't often happen with people who actually go into the court and try and preserve their rights. Most of the time, that's gone down before they've even filed the foreclosure, because the people know they're not paying, they know what's coming, and they rip everything out and abandon the property. So it does happen, but it's a bit overblown.
Have you ever heard of people that are in foreclosure that have decided to rent their home?
So you mean after the foreclosure is complete, they rented the home back, or that they rented the house out to a third party?
They rented it out to a third party when the foreclosure is going on. Can that be a wise business decision?
So it can. I mean, particularly if it was a rental to begin with, and uh, you can absolutely do so. You can rent out portions of it if you have. I have seen, and we've had clients whose property, went into foreclosure, and then they moved out of state. They've relocated for one reason or another, and so yeah, in the interim, renting it out gets you some income. Now, it can be a tad bit risky, because regardless of what that mortgage says, residential or not, as soon as you're no longer living in the house, you have legally converted that into commercial property, and the foreclosure process for commercial property is quicker, dirtier, and easier than it is for residential property. That being said, most banks will simply just follow whatever the mortgage says, and will file the foreclosure proceedings pursuant to that.
But generally, when we have clients who are going through really tough times and they really don't have, and they're out of a job, they're dealing with serious health issues. Like a lot of our clients are, they're just really they're in a bad time. They just don't have the income. And if they have already moved out of their house though, and the house is sitting vacant, but they still own it, I make sure they're in where, have you thought about renting out the house? Because this foreclosure case can go on a long time, and it sounds like you really need the income, and this house is still an asset of yours. You own it, and they get a tenant in there, and suddenly they're getting in all this money, and they can at least start paying for some of their medical needs and who knows what else. And then next thing you know, they got because they have a tenant in there and they're getting rent. Next thing you know, they're back on their feet, and then the lender ends up giving them a loan modification, and they save the house.
Well,
So,
it can also add an added bargaining chip too, because particularly in Cook County, and even more specifically in the city of Chicago, the banks do not want to deal with tenants, because it's a completely separate legal field then, because they not only have to deal with the foreclosure and deal with terminating the interest of the owner, but once that's terminated, and once they buy back the house, which in 90+% of judicial sales, the bank ends up buying back the house. Sometimes they go to third parties, but it's not common. Now they also have to deal with that renter, and that is a whole extra step for them. It's a whole other ball game, and Cook County, and again, Chicago, the city of Chicago in particular, has some extraordinarily renter-friendly ordinances and policies. And if a bank knows that there's a renter in there, it is added incentive to work with you.
So along those lines, have you had, or is it common for the banks to actually give your client money to move out of the house
Yeah.
during a foreclosure or after a foreclosure?
Yeah, it's not uncommon, particularly if there has been a bankruptcy discharge. I see it a lot more when the completed foreclosure, there's no chance that a completed foreclosure will result in money damages, because it's an incentive. Again, they're going to maximize the money they get back by getting the house back as quickly as possible, because it's less money, because at this point most of these banks are paying all the taxes on the property, they're paying the insurance on the property, interest is continuing to accrue on these loans, and they're not getting paid, and they're never going to get paid likely if absent a loan modification. And so offering money to get somebody out earlier is oftentimes going to be a better financial decision for them.
And also, when we have cases where we just have tremendous defenses that we've been able to raise, and the lender, you can tell the lender's struggling to get past those defenses, and especially when we have a client who really isn't interested in really saving the house, they just are concerned about the lender coming after them for all the losses. Some of our clients are hundreds of thousands of dollars underwater, and so that sometimes is a great opportunity, not only to say, hey, can you, we'll agree to let you take the house, but you got to waive, everything our client owes, the entire deficiency. And also, our client would be interested in cash for keys to wrap this thing up sooner as opposed to later. And then we have them over the barrel like that. And yeah, there's a lot that we can get, certainly in terms of money for our clients also.
And that's also the really tricky thing about dealing with banks and in trying to negotiate or enter into these types of agreements absent legal counsel, is that early on it's not unusual for a bank to offer cash for keys, but without any kind of deficiency waiver or consent foreclosure. So they'll offer you cash for keys. So they'll be like, here's $2,500, get out, and you don't want to be there anyways. And you're thinking, oh well, this is a fantastic deal, and you take their $2,500, you move out, they foreclose on you, and now they have $100,000 money judgment against you, because the offer was for money for you to leave, not to waive the money judgment, their rights to a money judgment against you. And so we're almost always able, like I have them offer those cash for keys, and I don't think I've ever not once been successful to then get them to also agree to waive the deficiency on them. A deed in lieu of foreclosure is where you literally just you execute a deed for the property back to the bank, and ideally it's in full satisfaction of the mortgage. Again, you have to be careful about that, because it's not always the same way. A short sale doesn't always result in a deficiency waiver. It's why it's really important to have counsel on these things, so that you're understanding the ramifications. But you're basically just giving back the house in lieu of them foreclosing on you. And a well-negotiated one will also include a waiver of any kind of money damages or money obligations. So it will be taking the house back in full satisfaction of the debt. It can be a good option. You can only do it if the only lien on the house is the mortgage that's foreclosing on you. If you have any other liens, you're not going to be eligible for it. But if you have one mortgage, and it's a really great, it can be a really good tool to avoid money liability, and also to avoid a foreclosure ever even being filed.
And I guess I have a question, because you brought up an issue that was really, really interesting. You said short sale. Can you tell the listeners how a short sale works?
Well, a short sale is where you sell the property for less than what it's worth, and the banks and lien holders, however many there are, agree to release the lien on the house and allow the sale to go through for less, while accepting less money than they're owed.
Well, I think you meant to sell the house for less than what's owed on it.
Yeah, that is, sorry, yeah, not less than it's worth. Sorry, less than it goods owed on it, and what less than the lien's worth is what I meant to say.
Right.
And they're willing to release the lien, take the smaller amount and release the lien. Again, a well negotiated short sale should also result in a waiver of any kind of money liability on any of the liens that you're negotiating away. They don't always. It's why it's really important to be represented when you're doing these things, because I have defended lawsuit breach of contract claims for balances that have resulted from short sales.
Steve and Jen, I want to thank you for joining us today on this topic. It's a very interesting topic, and you help a lot of people in need, and it's really great. And I wanted to say that we're going to sign off here from Arlington Heights, and I know you're up at the Libertyville office today, but I'm hoping to have you guys back on sometime in the future. So thank you.
It's great to be here. This was great. Thank you for having us.
Yes, thank you so much.
You've been tuning into Win with the Law with your host, Gary Newland. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, newlandlaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.